Good morning. Welcome to the Courtroom Files Live. Happy Friday. We're going to start in Judge Simpson's court. Many courts this morning are doing landlord-tenant, and this is from a little earlier today when he got his landlord-tenant docket started.
Plaintiff's claim in this case, including costs.
Total amount is $2,958.24.
Ms. Gray, how are you intending on getting that paid?
Oh, we just paid it yesterday. I think everyone left out the building before they got to it, but it's in the Dropbox like right now.
The total
The
total amount?
Yeah, the full amount.
Okay, and you don't have any knowledge of that, counsel? Huh?
No, I do not.
All right, very good. Here's what I'll do. I'll adjourn this out to, what is my next date? 21st? I'll adjourn it out 1 week. March 21st, 2025 at 2 p.m. That's an in-person hearing, but if everything's paid, it's likely they'll submit a dismissal. So you may want to check with the attorney's office just to make sure that's happened. Okay, ma'am?
Okay.
All right, thank you.
Thank you.
Is that it for you, sir?
Yes, I believe it is.
All right, very good. Thank you. Have a great day.
Thank you. You as well.
Court does call the case of 2 Miraloma LLC versus Rosalind Stovall. Did somebody enter here?
Good morning.
I'm here.
Destiny Hughes on behalf of plaintiff.
All righty, thank you. Ms. Stovall?
Yes.
Okay, she's here. All right, this is a termination of tenancy. Action, what's the basis for the termination of tenancy?
Your Honor, this is a complaint for possession after a mortgage foreclosure sale. The redemption period has expired.
Gotcha. Okay. And Ms. Stovall, what's your position on this?
I have been in contact with the lawyer Ben, and I asked him how much it is. So I had been working on getting my credit straight, and I finally got it straight. And now I'm working the loan, they're processing the loan for it, and they told me that I could pay $140,000 for it. So that's what I'm working on now. So I asked for an extension because they don't know how long it's gonna be. It's gonna be like maybe five days or so, and I don't know. I'm just waiting for them to give me the money so that I could buy my house back.
Okay, so you're gonna have to help me with these people you say you were in contact with. You were in contact with the lawyer.
Yeah, Ben Price, who is a representative for Miraloma. And I have been in contact with him, and I asked him how much is it gonna be, and he told me it's $140,000.
When did that happen?
It's been two weeks ago, I believe, that I talked to him.
Counsel, you know anything about that?
I'm looking back through emails at our firm. Ben Price does work at our firm, and he did work on this mortgage foreclosure action, but I'm looking back. I do see an email saying the lender would accept $140,000, but as of now, as far as I know from the client, we're moving forward with the eviction action. We haven't received anything from defendant saying she's going to pay, so the client, as far as I know, wants to move forward.
Well, yeah, and I did. That's why I asked how much it's going to be, because I did ask him that, and I hadn't heard back anymore from him. And I told him that I was working on it because I had to, what I'm paying off is a hard money loan because I didn't have good credit. And so I finally got my credit straightened out, and I'm getting a loan, so it won't be a hard money loan. So I asked him how much it was going to be. He said $140,000, and I said, okay. When I talked to him, I said, okay, that's what I'm going to pay. So that's
okay. So that was 2 weeks ago.
Yes.
Correct. So all right. Here's what I'm going to do. Let's try to get that straight and make sure everybody's headed on the same page, because seems like it might be conflicting. I'm going to adjourn this out 1 week to March 21st, 2025 at 2 p.m. That's an in-person hearing, and then we can figure out exactly where the parties went ahead with this. All right.
Okay, thank you, Your Honor.
All right. Thank you.
Okay, great. Thank you.
Thank you, Mr. Maple Heights Apartments versus Hussam Al Musawi.
Good morning, Your Honor. Alex Wilson appearing on behalf of plaintiff.
They're here. Al Musawi.
Sir,
All right, very good. All right. Got him there. And what is plaintiff's claim in this case?
This is a non-payment of rent matter. I show rent outstanding in the amount of $1,942.81, excuse me, court cost of $170.05 for a total outstanding balance of $2,112.86.
And sir, how are you intending on getting that paid?
sir, I don't owe them anything.
Okay, so
I don't know.
are you
where-
saying that it's been paid?
No, sir. They've been claiming this for about 3 years, and now the court is here. So I've been asking, why do I need to pay this for what? And they have not yet provided me with any reason why I owe them this money.
Okay, let me ask you this.
Yes, sir.
We're in March. Did you pay rent in January, February, and March to them?
I
Well,
got
don't show me anything because I can't see it, but
think-
just answer my question.
Yes, sir.
You did?
Yes, sir.
So counsel, from when is this on his ledger? He's, I think, claiming it was a while ago, but
Yeah, there's been a running balance since early 2024. He has been making payments, but there is still that running balance. So he did make payments in March, in February, and January, but it never zeroed out his account.
okay, so has he been paying more? I don't know if you can quickly see, has he been paying more than what his rent is, like knocking down the balance, or has he been paying exactly what his rent is?
He's been
Or
paying
less.
exactly what his rent and late fee is. So his rent is $480 plus a $10 late fee, and he's been paying $490. So it hasn't
Okay,
brought down the back balance.
all right. Is this a subsidized unit?
Yes.
Okay. So looking back, and again, counsel, I don't know if you can see this, do we know where that amount came from?
I don't think I have that on the ledger that I have today.
All right. So, Mr. Al-Musawi, was there a point in time where there might have been a break in your subsidy or your Section 8?
Yes, sir. A couple of years ago, appeared in front of you when my rent went from $25 to $800 because they put me under something like a Section 8 or something, and then took me off without my notice, and then wanted the full payment off the contract. And when we appeared in front of you, you have explained that this is not going to happen, it's not possible, and the case was dismissed. I believe this whole issue derives from that one day, a couple of years ago, and I have emails and everything about it. So that's the only time ever that I did not pay.
No, I hear what you're saying. I can't say I previously recalled that case because
Yes.
I've had a lot since then, but that's what it's sounding like to me. Like at some point there's a break in the subsidy, and for whatever the reason is, the subsidy doesn't get paid. It's on your account, and either somebody was supposed to pay it or I don't know. So here's what I'm going to do. Counsel, I guess we're going to have somebody look back at that and figure out how that got on his account so that the court can know. I'll adjourn this out 1 week, 21st, 2025 at 2 p.m. That's an in-person hearing. So it might be that we just have to kind of look back and see where it came from and see if it was a subsidy payment, but you were really supposed to be on a subsidy, if that can be corrected, or how we'll have to figure it out once we figure out what it is. Okay?
Thank you very much.
Good. Thank you, Your Honor.
Thank you. Beal Properties versus Mariah Nelson.
While we're waiting for parties to announce their good morning, happy Friday again. My name is Dan. Welcome to the Courtroom Files Live. Lots of landlord-tenant going on this morning, as is typical for a Friday morning. As Judge Middleton calls it, it's his docket where it's an exercise in misery, where we get to see about all the people who are struggling. But I'm watching several courtroom feeds right now. Pretty much everybody's running landlord-tenant except for Judge Meineke, who is on the phone with somebody right now. We're waiting for Judge Fleischer to come online. And I'm watching Judge Slavin and a couple of others as well. Let's get back to court.
$1,598.32, requesting a writ date of March 24th.
Judgment to the plaintiff by default for possession. Redemption amount is in the amount requested. Writ to issue in 10 days.
Thank you, Your Honor.
Augusta Woods Community versus Rachel Lindberg and William Lindberg. Lindbergs, they are not present. You may proceed.
Sorry, Your Honor, I'm just looking for the file. This is also possession only for non-payment of rent. Current rent owed is $558.37. Court cost is $179. Total redemptive amount is $737.37. Requesting a writ date of March 24th.
Judgment to the plaintiff by default for possession. Redemption amount in the amount requested with the writ to issue in 10 days. Rocco Cambridge Club versus Kimberlyn Collins and Crystal Collins.
Laura Kirby, Your Honor, on behalf of plaintiff.
Hello, Ms. Collins. You're muted.
Good morning, Your Honor.
All right, what is plaintiff's claim in this case?
Your Honor, this is non-payment of rent. Current rent owed is $4,897. Court cost is $173. Total redemptive amount is $5,070.
$5,070. Okay, and Ms. Collins, how are you intending on getting this paid?
I am not intending to get this paid at all, Your Honor. I submitted something into the court yesterday. They said they would put in your chamber, and with this case, I filed something against ROCO, a small claims against them, and I asked for these cases to be combined.
Okay. Counsel, do you know anything about the small claims? Probably not.
No, Your Honor, I was briefed I have a note in my file briefly that there is some habitability issues, but I have no problem combining them as they do relate to the same. Or she could just file an answer to this non-payment case.
Well, okay, so first of all, what road is this property on?
It's off of Zeeb Road, Cambridge Club Circle Drive, like Zeeb and Jackson
Off of
Road.
Zeeb and
Yes.
Jackson?
Yes,
So
sir.
it's what, that Scioto Township, I guess?
Yes, sir.
What? Was this small claims filed in 15th or here?
In 15, yeah, in the 15th district. And when I went to see if I could have these combined, they said that they didn't know how ROCO filed in 14, but it would be up to you to, combine them or
Well,
make
I
them.
don't know that.
I
It
don't-
says
I
Ann
don't
Arbor,
either.
But it could, well, but ma'am, I don't know if this is SIO. Can you put this address in there? Because one of these two cases is in the wrong spot. While we're doing that, and I'll pass it just briefly. Beal Properties versus Call, Beal Properties versus Roundtree, Augusta Woods versus Brown, Augusta Woods versus Dabner or Darnier, Augusta Woods versus Davis, Augusta Woods versus Floyd, Augusta Woods versus Gurney, and Augusta Woods versus Roden. Those matters are dismissed on plaintiff's motion without prejudice. We got it, yeah.
Let's go over to Judge Fleischer's court. He just came online and he's looking very shiny today. That's, you know, he always dresses interesting, but that one's bold.
You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Okay.
Okay.
On March 9th, 2025 in Harris County, Texas, officers were dispatched to a suspicious person call. Officer met with the witness who stated that the defendant was looking for her children and was at a nearby residence. The officer then made contact with the complainant at the residence, who stated the defendant had been intoxicated at a family gathering earlier, and they began to argue at home before the defendant assaulted the complainant. The defendant admitted to striking the complainant with the television. The officer noted the complainant to be bleeding from his face. The complainant is her ex-husband.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to have any contact with this complaining witness and not to be in possession of any weapons. Do you see a protective order that has been issued in this?
It needs to be, signed.
Okay, ma'am, I'm issuing now what's called a magistrate's order for emergency protection that identifies Mr. Roberto Baron as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. Stalk, threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. Do you understand?
Yes.
If you violate this court order, the state can and probably will file a violation of protective order. That is one of the worst cases you can pick up. Just don't have any contact. Don't use alcohol, any dope. You'll be fine.
Okay.
Just, I'm going to protect my city at all costs. And if that means putting you in, I'm going to do it in a heartbeat.
Okay.
Now, do you have the ability to hire a lawyer, ma'am?
No.
Do you work?
Yes.
Okay, you work full-time?
Yes.
Okay, I'll have you fill out an application. Do you have any children?
I have 3.
Okay, I'll have you fill out an application. Let me take a look at it to see whether you qualify and then we'll talk. Do not leave until you sign our bond conditions though. Don't worry, because since she'll be monitored for no alcohol, we'll have Felicia do it. Okay, please. Deputy Miranda will give you an application. Hey, you're back.
I didn't sign.
You ready?
I am always ready.
Let's rock and roll.
Judge, was this one CHA?
No, I gave her an application.
Is it smoking jacket thing, Judge, that I missed? No,
You did. It's okay.
no. Smoking.
Well, it's too early, man. Come on up, sir. Is it De Los Santos you said?
Yes. And it was under Santos
Yes, page
on the
19.
docket, but it's.
I see it. Got it. All right, Mr. De Los Santos, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine because of the high blow. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 9th, 2025, at approximately 6:34 a.m., an officer responded to a major accident on the 6100th block of North Fry Road in Harris County, Texas. The officer made contact with the witness, who was traveling south on North Fry Road and stopped at an intersection of West Little York Road, and he began to drive. When the light turned green, he was struck from behind He exited his motor vehicle and observed the defendant in the driver's seat. The officer observed rear damage to the witness's motor vehicle. The witness stated the defendant was transported to the hospital. The officer observed heavy front damage to the defendant's motor vehicle, but no closed or open containers in his motor vehicle. The officer made contact with the defendant at Katy Memorial Mental Hospital. Defendant stated that on March 8th, 2025 at 6 p.m. he was drinking at a friend's house. The defendant stated he drank until 4 a.m. the next morning. He admitted to driving under the influence, resulting in a major accident. The defendant had visible scrapes and injuries on his face, arms, and legs. The officer observed the strong odor of alcohol upon his breath, red bloodshot eyes, and slurred speech. SFSTs were administered. 6 out of 6 were observed on the HGN. The walk and turn and one leg stand could not be conducted due to injuries. IVs, and the defendant had IVs and the defendant was wearing a neck brace. The nurse checked his vitals and ensured the defendant was in good health to be discharged from the hospital. The defendant was read the DIC and agreed to a breath test. The results were 0.166 and 0.169.
How long from the time of the accident to the time that he goes to the hospital? Is it immediate?
So I don't believe it states what time the accident occurred and what time he was transported to EMS, or transported to the hospital, but it's before the officers were able to arrive on scene and do an investigation of the accident.
He doesn't write down what time the accident is? Do you have the OR?
Been a lot of that going on lately in DIMS.
I don't understand who's writing these reports.
I don't know, I thought intake was
No,
supposed
I
to
don't get it.
improve on January.
It's, it's important to know how long it takes him to get to the hospital, right? And then how, I guess he's discharged immediately after he gets to the hospital. I mean, that can't be because he does, how long does it take to get into an emergency room? It takes forever. When I have a family member that goes to the hospital, it takes 12 hours just to get seen.
Yeah.
And then he goes and he blows a 16 after. I mean, look, I'll give you a little bit of time. Take a look to see.
And hopefully the office report can clear it up. We don't have that back yet. Correct.
I just want to know that there's not a disconnect. Like it doesn't take 12 hours to get from here to here, because you know how long it takes to get to hospitals, and it's ridiculous. So yeah, I'm going to put it on hold for now because we got a whole.
Today or?
No. Later, like I'll give him a couple, like maybe an hour or so. Do you have
Okay.
anywhere else to go?
I have plenty of places to go.
Yeah, I bet. So go do what you need to do. Come back. Let's revisit PC in a little bit. Will you? Please?
Absolutely.
Okay. Take a seat if you're in the jury box. Don't leave.
Either way, it's the same day, just no matter what.
And then I think that we need to do a name change because they have it under Santos, but his name is De Los Santos. De Los Santos is the last name, not just Santos. Nathan, and it's De Los Santos.
That's correct. All three separate.
Or a name change. Right. But it starts with De Los Santos. Right. So that's, yeah. We're going to do a name change.
So we do have an office support back.
Okay. Are you ready now, or do you want some time to look?
Can we have? Yeah.
Can I make a suggestion? Based upon the offense report not having any, go ahead and stand here, and the DIMS report not having the information that they're seeking, I think at this time, no problem cause finding is appropriate. However, it's my understanding that Chief Pace, since I trained him, will probably go and figure out all these facts and get it refiled correctly.
I wanted to give you a little bit of time. If,
Huh? I'm gonna contact the officer.
And we already.
I didn't want to go that far. I wanted to just see what the report has. Because you being able to go contact the officers a little bit just beyond this, because it's not fair to them. But what I'm looking for is how long it takes from the accident to get to the hospital, to see, is it him that's driving? Is he intoxicated at the time of driving? Because that's what's I mean, that's what it calls for, right? That's what we need to know. So if you can just take a look real quick, go do what you need to do, come back maybe like 45 minutes. I just want to know what the timing.
I was just gonna suggest, we already have a date of 4/14, that they could get this done in the interim and not have to scramble today with 50 other arraignments. That's all I was suggesting.
And
But
Judge,
it's up to the
looking
court.
at the OR, the timeline is not.
It's
the
not in
OR
there.
for that.
They didn't put any time in the OR?
The times that I have is that the witness said that they had been there since 6:30. Sorry, I don't know what that is about, but the only time that I have is that the blood sample was taken at
Breath, right?
8.
Breath, right.
He didn't write time. He didn't write down what time the accident happened or what time he gets on the scene. There's got to be something, you know? Look at the MDTs. Look at, there's got to be a time when dude.
I'm looking at the wrong offense report, Judge. I apologize.
It's okay.
I do have, based on the accident report, the crash time was 5:50 in the morning. And I'm not seeing, what we don't have here, Honor, is I think the time.
I'm not concerned about that. I'm concerned what time he gets to the hospital.
Yeah.
Crash occurs at 5 something in the morning.
Okay.
Does
And
he get
he's
to the-
admitted to the emergency room at 7 a.m. So it's roughly about an hour after.
Well, he gets admitted at 7 a.m.
Yes.
Okay, so we're about an hour and a half after the crash. What time does the officer get there? Start interviewing? Do you know?
The crash is at 5:50 a.m. The officers transport the defendant in at 6, so 10 minutes later. And
They transport him to the hospital?
yes, and
Okay.
it's admitted in the emergency room at 7.
What time does the officer get there to start the interview? Mr. Beadle, I just want to know that everything is in close proximity because if he gets there, he starts interviewing like 12 hours later, I'm gonna have a problem.
And I think the DIMS will probably be supplemented appropriately. I know how much business you have today. I see all the arraignments here sitting in the audience. I think that they will get it done by the 14th of April, which is what I already have the date for. But I leave it to the court's discretion. I'm fairly certain it's not in there. You're doing great, by the way.
Your Honor, I don't see a time. It just needs to follow right up the hospital.
And the blood draws what time?
It is at.
Or the breath test, sorry.
Which is weird in and of itself, Judge, because they said he couldn't do the one leg stand or the walk and turn.
Because
But then they took him off to another location to do a breath test. It's just kind of weird.
It doesn't state that.
You don't even have the time of the breath test?
I no.
So it looks like if we're looking at her call, I would ask that report, she would leave right to review it before considering paid.
What do you think?
We have a date for the 14th. I'm sure they'll do it before
Okay.
then. His appearance is waived anyway, so he doesn't have to be here.
Okay, so,
Do you want to put some potential conditions on
No, I
him,
know.
assuming? Okay.
so I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. Any prior DWIs? And valid license?
No prior DWIs and his driver's license is valid.
Okay, as long as you have valid liability insurance and a Texas driver license, you may continue to drive. But if you don't have car insurance, do not drive. It is a condition of your bond. Don't consume alcohol, don't use illegal drugs. Do you understand?
Yes, Your Honor.
We'll waive your appearance while you're on bond in this court, but you must stay in touch with them. If they tell me they can't get a hold of you because you're ducking and dodging or you pick up a new case, all bets off. I will put you in jail. You
Absolutely.
understand? Okay, I'll have you sign a reset with Victoria. We'll get you with Fleischer, your bond condition, then you're free to go. All right, Mr. Beadle, always a pleasure. Happy Friday.
Have a great weekend.
You too.
All right.
Hi, Maria, you ready? Come on. You have an arraignment? Okay.
Real quick, once again, Judge has massive problems with the quality of reports that are being written by the Houston PD and surrounding jurisdictions. I don't know if this judge is just that sensitive to it or if this is like a national problem, but the quality of the police reports, at least as Judge Fleischer sees, it's really bad. Let's go ahead and go back to him.
Really? Lechuga. Yeah. All right, good morning, Mr. Lechuga. Good morning. So you're charged with displaying a fictional license is a plate, right? That's it. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 7, 2025, at approximately 6:32 a.m., an officer observed a vehicle with expired registration as of June 2021. A traffic stop was initiated. The officer ran the license plate and it returned to a different vehicle. The officer made contact with the defendant, the sole occupant, and the defendant stated he purchased the vehicle 7 months ago and had not been able to register the vehicle due to long work hours. The defendant was detained and the defendant stated he had already received a citation for displaying a fictitious license plate by the LaPorte Police Department in January of this year.
Okay. Can you run his license, please? Does he have a license? Mr. Lechuga, I'm going to find that there's sufficient probable cause to go forward with your case. I am placing conditions on your bond now that you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name, car insurance. God forbid you get into an accident and you maim someone and they come after you and sue you for $50,000. Got to hire a lawyer. You'll never crawl out of that hole. That's why you get car insurance, because they're not on purposements or accidents for a reason. When you have insurance, they represent you. They'll get a lawyer for you. That's why you need it. If you don't have it, don't drive. Do you understand?
His driver's license is eligible.
Okay. So as long as you have those two, you may continue to drive. Because you have a lawyer, I will waive your appearance so you don't have to waste your time coming to court, but you must stay in touch with Casanova and Mish. They'll tell you if and when you have to come back to court. She tells you that you pick up a new case, you start acting a fool in the free world, I will take it away from you. All right, I'll have you sign a resale with Victoria and then we'll get you out of here. Thank you.
There's no driving affidavit?
Just, can you file conditions, no driving without insurance?
Yeah.
We'll have you sign these conditions and then you're free to go. Okay. States conditions.
All right, Judge, next is page 5, Escamilla. Come on up. All right, counsel, we're looking at today. 13.
I'm like, Brandon. You were on bond for an assault case that have taken off on us at least 3 different times, and now you've picked up a new case. You were charged with failure to identify oneself while being a fugitive from justice. On that case, you're now facing a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On March 7, 2025, at approximately 4:44 p.m., an officer observed a vehicle with expired registration as of December 2024. A traffic stop was initiated. The officer made contact with the defendant, the driver, advised he did not have any form of ID on his person, and provided his name as Daniel Escamilla, date of birth, April 24th, 1998. The officer did a search and saw the defendant did not resemble the Texas driver's license that came up for Daniel Escamilla. The officer got a hit for David Escamilla, the defendant's real name, and saw there was an outstanding warrant. The Texas driver's license photo for David Escamilla resembled the defendant. The officer utilized mobile APIS and confirmed that the defendant was David Escamilla. The defendant admitted to providing the officer with his twin brother's information instead of his own due to the open warrant.
Do you see if he has a license? Can you check, please?
Yeah, he's ineligible, Judge.
Okay, Mr. Escamilla, I'm going to have you sign an affidavit with me today. I don't give a rat's behind what is going on in your life. If you don't have a Texas driver license and liability insurance, you are not to drive. And if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you get into a car. Do you understand?
Yes, sir.
You have a lawyer, Mr. Escamilla.
No, sir.
I'm going to appoint you a lawyer today. Your case, your assault case is 1,000 days old. We are going to figure out what happens with this case today. Can you appoint him a lawyer, please? If this case gets reset today, you will get an ankle monitor, and I'm going to send you for a drug test right now. I want to ensure that you're not using anything as well. You know what? Let's just do that now. Police, if you can send him, please. If you fail to take the test, if you fail to come back, I'm going to make your bond so high you'll have hair falling out. Do you understand?
Yes, sir.
The next time you take off on me and fail to come to court, so help me on those bonds. Do you understand?
Yes.
Take a seat for me.
Mr. Scott, will be here, please? Judge, any other notes?
Yeah, GPS monitor gets it on today. No alcohol, no drugs, no contact with the complaining witness in the assault case.
Yes, there's a pen right here.
And I'll find PC on the new case.
Sign your reset, please. All right, thank you.
Right, Judge, you ready?
Yeah, go for it.
The next one is gonna be page 7. Golf. Is a felony on the warrants of the.
We've got eyes on several different courts this morning. I'm currently watching Judge Simpson, Judge Meineke, Judge Washington, obviously Judge Fleischer, but we're going to go ahead and stick here. He's the most intriguing at the moment.
Because you are on deferred for an aggravated assault of a family member. It looks like that's in warrant status now and no bond, actually. With us, you've picked up a possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 5th, 2025, at approximately 11:50 p.m., an officer observed a vehicle parked in a handicapped parking space with no displayed license plate or placard, and then leave the parking lot. The vehicle had expired registration as of July 2024. A traffic stop was initiated. The defendant was the driver, and he was ID'd by his Texas ID card. The officer observed the strong odor of marijuana emitting from the vehicle, and the defendant admitted to being in possession of several small plastic bags of marijuana under the driver's seat. A probable cause search was conducted, and 4 bags were located under the driver's seat, 0.154 ounces.
All right, Mr. So he doesn't have a license, correct?
His driver's license is eligible, Your Honor.
Mr. Goff, I'm going to find that there's sufficient probable cause to go forward with the case. I'm not putting any conditions on your bond now. Just behave. That's all I'm asking you to do. You know, you're on felony probation. You're supposed to have a halo over your head, you know? When you don't, bad things happen, as you now see. Can you go ahead and appoint him a lawyer now? So I'm going to appoint you a lawyer so that you can speak to someone. We'll take you into custody now. You'll probably hit felony court Monday, and then we'll just give you a reset of like a week or two to figure out what happens. Okay? All right, man. Good luck.
All right, Judge, next is page 14. Martin, James. Wayne. I can.
What was the last name?
Page 14, novel 40, Martin.
Good morning, Mr. Martin. Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 8th, 2025, officers were dispatched to a weapons call at 821 Custer Street in Harris County, Texas. The caller stated that there were about 10 people fighting, and the caller saw a gun. The officer observed a multitude of people walking from the street into the property and saw the defendant fitting the description as the person with the gun. The officer approached the defendant, and he admitted to having a gun on his person. Upon a frisk, the officer found the outline of a firearm in a crossbody bag on the defendant's person. The officer removed the handgun from the bag. The defendant is 19 years old.
What's he doing wrong? All right, I'm going to find no probable cause in your case, Mr. Martin. Be careful. You know, you're 19, you have a gun. God forbid you use it. Put yourself in such a deep hole. You know, really. Go to school, get some knowledge, get a good job. You'll get a ton of money, and then life's great. Life sucks without money. I promise you. Don't end up in a hole, hang out with dogs, because all you're going to do is get fleas, you know? Take a seat, please.
All right, Judge, next is page 14, 15, and 16. Martin, Joseph, come on up.
Joseph Martin?
Yes, sir.
So, Mr. Martin, you have a total of 4 open cases. You're charged with 4 counts of assault. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 8th, 2025, officers were dispatched to 4527 Perry Street in Houston, Texas, in Harris County regarding an assault. The complainant, Hayes, stated that she was in a verbal argument with the defendant, and that led to her being pushed by the defendant. Complainant Hayes said that she hurt her hand due to being pushed into a car with the defendant and that she felt pain. The complainant, McDaniel, then stated that she confronted the defendant to see if her friend getting assaulted by the defendant. The defendant then started swinging and struck the back of Daniel's head, and that complainant felt pain as well. Complainant Powell then stated that she was assaulted by the defendant due to also trying to defend her friend, complainant Hayes. Complainant Powell says that he approached them to confront the defendant, and the defendant just started swinging and that she got struck by the defendant. Complainant Powell stated that she was not recall how that she was hit, but that she felt pain. Complainant Martin stated that she knows the defendant from school and they both attend TSU. The complainant Martin stated that she was trying to calm the defendant down but does not remember the physical assault due to her being knocked out unconscious by the defendant. Complainant Martin felt pain. A witness stated that she saw the whole incident and saw that the defendant was arguing with complainant Hayes and that the defendant started pushing complainant Hayes into a vehicle. Complainant Martin was then trying to de-escalate the situation and stated that when she saw complainant Martin get struck by the defendant and get knocked unconscious for approximately 2 minutes.
Is that number 3 or 2?
That's 4.
That's the 4th.
That's the 4th, Your Honor. The witness then stated that she saw the defendant punch complainant Martin on the left side of the face. The defendant admitted to being involved in the physical altercation with the complainant and pushing them away. The complainant 2 had a knot on the back of her head. Complainant 3 had a small swelling on the left side of her face. And complainant 4 had small swelling under her left eye and was transported to the hospital due to being unconscious.
All this happens at TSU?
It is. It was a party, yes, Your Honor.
Mr. Martin, I'm going to find that there's probable cause to go forward with your case. I'm now barring you from going to TSU.
Yes, sir.
I'm barring you now from going to TSU.
Oh.
I'm also ordering you as a condition of your bond not to have any contact with any of the complaining witnesses in this case, not to consume alcohol, illegal drugs, not to be in possession of weapons. If I find that you're a danger to my community, I will do everything in my power to take you off the street. Do you understand?
Sir, I understand. May I ask what this bar? Okay.
You have the ability to hire a lawyer, Mr. Martin.
No, sir.
You work.
Yes, sir.
I'll have you fill out an application. Deputy Miranda will give you an application. I'll see whether you qualify for an appointed lawyer. I'm going to have you sign a receipt with Victoria. Then I'll have you meet with Felicia for your bond conditions. Life is way too short to sit in a box that's 6 by 9, man. Keep my city safe. Otherwise, it's going to go sideways real quick. You understand?
Yes, sir, I understand.
Okay, come on.
Thank you. I'll go.
Right this way. All right, Judge, next is page 16. Gordo Angel.
So don't worry about filing conditions because I'm going to have it done with Fleischer. So we'll have a monitor for alcohol.
Good morning, Honor.
Good morning, sir. Let's finish this real quick.
Look at this side, so reset page. You reset for your next court. Yes, yeah.
Okay, what was your last name again?
Mejorado, Mejorado.
I see. Okay, Mr. Mejorado, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On March 9th, 2025, at approximately 3:30 a.m., officers were dispatched in response to a motor vehicle that ran off the road. The officers respond to the defendant's motor vehicle, a Dodge Ram, in a grassy area adjacent to a service road on the East Freeway. Service road in Harris County, Texas. The officer observed the defendant and walked over to the defendant walked over and advised that he was leaving the parking lot and lost control of the motor vehicle when he drove through the puddle of water. The defendant's motor vehicle left the road and got stuck in the mud. The defendant stated his friends were there helping him pull the motor vehicle from the mud. The officer observed glassy eyes, slurred speech, and odor of alcoholic beverage. The defendant stated that he did not have anything to drink, and the officers relocated him to JPC to continue the investigation. SFSTs were conducted. It was a 6 out of 6 on the HGN, a 3 out of 8 on the walk and turn, and a 1 out of 4 on the one leg stand. The DIC was read and consented to grab, and the results were a .148 and a .143. It was identified by his Texas driver's license.
Yes, sir, I'm going to find that there's sufficient probable cause to go forward with the case. You look to see any prior DWIs, and if he has.
There's no prior DWIs, and his license is.
Okay, Mr. Mejorado, I'm ordering you as the condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Likewise, if I find that you're driving without insurance, your bond will be revoked. You will go into custody. You understand?
Sir.
Do you have the ability to hire a lawyer?
No.
I'll have you fill out an application. I'll look to see whether you qualify. Deputy Miranda is going to give you an application. We'll have you fill it out. I'll have you sign a reset with Victoria. You'll get with Fleischer for your bond conditions. Then I'll take a look at it shortly. Please.
All right, Judge, counsel is approaching on page 6. Alon, Rachel, come on up.
Okay. Happy Friday. How are you?
Good.
Good. We made it. Good morning, ma'am.
Good morning.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, ma'am.
On March 9, at approximately 3:14 a.m., the officer observed a vehicle driving without taillights and swerving in its own lane side to side. The officer observed the vehicle failed to maintain a single lane and merged into another lane, almost colliding with the vehicle in that lane. A traffic stop was initiated. The officer made contact with the defendant, the driver and sole occupant of the vehicle, and she was identified by her Texas driver's license. The officer observed the defendant have bloodshot eyes, blurred speech, and odor of an alcoholic beverage on her breath and person. The defendant stated that she had 2 tequila drinks. SFSTs were conducted. This is 6 out of 6 on the HGN, 4 out of 8 on the walk and turn, and a 2 out of 4 on the one leg stand. The DIC was read and the defendant consented to breath. The results were at 0.137 and 0.132.
Okay. Ma'am, I'm going to find that there's sufficient probable cause to go forward with the case. You also look prior to WI's license, please.
Yes, Your Honor.
I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
Judge, on the testing, what is that? If I can pass on that message.
Just random testing. No alcohol, no dope,
Okay.
illegal drugs.
Yeah, I guess just so I can pass it on, if there's a pattern of nothing, can he reapproach in the future?
Of course. It's gonna, I mean, don't come in 2 weeks though.
No.
Right. But yes, of course.
License is eligible, no priority.
Okay, so you have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with them. They'll tell you when you have to come back to court. As long as you don't pick up any new cases, we'll be fine. I'll have you sign a reset with Victoria. We'll get you with Felicia for your bond conditions, then you're free to go, man.
All right, thank you very much.
Have a good day.
So normally I try to move around from court to court, but we're going to ride with a shiny Judge Fleischer here until further notice. I've got my eyes on 6 other courts, and it's either landlord-tenant or they're out on recess, or in the case of Judge Washington, there's like no audio from the defendant's podium. So we're just going to stick here.
Don't put your stuff on the table. Yeah. Right here in front of the judge.
Good morning, Mr. Robinson.
Good morning, sir.
Sir, you're charged with terroristic threat. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 7th, 2025, in Harris County, Texas, at 315 Capitol Street in Houston, Texas. The complainant is a security guard for the building and was walking around Bagby when he found the defendant sleeping on the sidewalk. The defendant was not supposed to be there, and the complainant told him repeatedly that the defendant was not allowed to be there until around 11 p.m. at night. The defendant then began to get hostile and aggressive and threatened to shoot the complainant while slowly reaching into his bag. The complainant feared for his life.
Did you say he's not allowed to be there until 11 p.m.? Did I hear you say that? What is it?
I don't know. When the complainant, we did not charge a trespass in this case. So when the complainant said you're not allowed to be there, we back at 11, and that's when the responded.
Can you say it again? What did he say again?
Complainant repeatedly told the defendant that he was not allowed to sleep there until after 11 p.m. to 7 a.m. And since it was before 11 p.m., he was therefore trespassing and not allowed to be on the premises. The defendant had threatened the complainant that he was going to get his gun and shoot him by signaling this might go in his bag with his plant field first.
He said, I'm going to get my gun and shoot you?
I don't have it both, but I say the defendant threatened the complainant that he was going to get his gun and shoot him, signaling this by going to his bag.
Who wrote the report? The actual officer who got threatened or someone else?
The officer did not write the report. I mean, the officer wrote the report, not the security guard. The security guard was the one who was threatening.
Mr. Robinson, I'm going to find probable cause for now. Okay. Let me give you a lawyer. talk to the lawyer. Just don't have any contact with the security guard. That's the only thing I'm gonna ask you to do, right?
If I might say real quick, I know you're busy. They have a city ordinance, that's why you can't lay 11. But I was recently jumped, I got my medical records.
Look, don't tell me because I've got a bunch of DAs. I don't want you to say something that hurts the case. Let me give you a lawyer. Everything you say, when you want to tell me, tell the lawyer, and then they can tell me
I
what,
understand.
okay?
Speaking of the defendant works this location, and we're not in contact with this location.
What is this? What is this place?
It's in the hospital building downtown.
That's the tongue, that's where I was at.
Don't go back, please. The problem is I don't want you to run into the security officer, then more bad blood comes up. They file more charges. That's why.
I understand, I never said that I ain't tripping. Already filed a motion for discovery inspection, so I didn't even have a bag on me.
Don't worry about it. We'll take care of you. I'll have you sign a reset Victoria. We'll have you take a seat. Let me find your lawyer. and then- Okay, please.
Right this way.
If you can file this, please, the condition. No going back. Sorry?
Whenever you're ready to sign.
Yeah. I thought I signed it. Yeah, I signed it already.
You didn't know just now.
Yeah, so we can get them out. Mr. Lechuga, come up. We'll have you sign your condition. We'll get you out.
All right, Judge, you ready?
Yeah.
Next one is page 22. Villasana.
Mr. Mitchell, please. Might be signing your evaluation.
Good morning, Mr. Villasana. Morning. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 7th, 2025, at approximately 7 p.m., officers were dispatched to a person found on the West Middleton Road in Harris County, Texas. The officers spoke with the witness, who the witness stated that the defendant was parked when he got to the location and was asleep in his motor vehicle. The vehicle was turned on with all doors were off. The witness stated that he knocked on the window multiple times to see if the defendant wakes up, that the defendant did not respond to knocking, and that the witness had to use a special tool to open the door and was not able to get the defendant and seemed a little bit off. The witness stated that the defendant had told him that he had been drinking a few hours prior to driving to the gas station, and that he observed a brisk man in the middle of the car, asked the defendant about it. The witness stated that the defendant had been in the hospital 3 days ago for alcohol problems. And another witness stated that multiple customers had stated that the defendant had been parked at the gas station, and when that gas station made accessible witness to the cameras and saw the defendant's car had been parked there since 6:30. The witness too went outside to check on the defendant, and the defendant was asleep and tried to wake up the defendant by knocking on the door, but he did not wake up. The motor vehicle was on. The officer observed a strong odor of an alcoholic beverage, poor balance, and disorientation. He refused SFSTs and admitted to consuming alcohol a few hours prior. An open container of Jim Beam bottle was locked in a hidden compartment of the passenger seat, and an empty can of Four Loko was located in the center console. A styrofoam cup with a lid and a cup holder with a liquid matching the color of the liquid in that Jim Beam bottle was also found. The DIC was read and the defendant refused breath. The blood warrant was signed and executed and was identified by his Texas driver's license.
Are you telling me that he had alcohol in the car while driving?
Yes, Your Honor.
Mr. Villasana, I'm going to find that there's probable cause to go forward with the case. I'm now ordering you not to drive any vehicle whatsoever for any reason. Do you understand?
Yes, sir.
If I find that you do, I can have a contempt hearing. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months of jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
I'm also ordering you to obtain a portable device that you're going to take with you everywhere you go to prove to us that you're not consuming alcohol. If you have a problem with alcohol or illegal substances, you better address it. Because if you don't, and it becomes a problem, I'm going to do it for you. And I promise you're not going to like the way that I do it. Do you understand?
Yes, Your Honor.
I am sending notice to DPS and I'm placing a restriction on your license that you are not allowed to drive any vehicle that doesn't have an interlock on it. I'm sending notice now to DPS in Austin so that every police officer in this state knows that if you're caught driving a vehicle and that vehicle doesn't have an interlock, they will take you to jail. Because I'm ordering you not to drive now, that's why I'm giving you a portable device. But do not drive. Do you understand? You get no more warnings. If I find that you do, I'm going to lose it. Do you have the ability to hire lawyers, sir?
Sure.
Okay, we will give you time to go hire a lawyer. I'm going to have you swear to us that you're not going to drive. I will get you to Victoria where we will have you sign a reset. You will get with Fleischer your bond conditions. After that, you're free to go. Be careful, Mr. Villasano. Okay.
First, this is the.
All right, Judge, next is a Spanish speaker, page 3, Castillo, Alejandro.
Buenos días, nomás escucha el juez. Dice.
Mr. Castillo.
Bottom of page.
Yes, Judge.
Okay. You are Alejandro Castillo.
Yes.
Mr. Castillo, you're charged with failure to stop and give information. Essentially leaving the scene of an accident without exchanging information. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 6, 2025, at 9 a.m. Officers were dispatched to a dispatch at a location in Texas. Upon arrival, the officer met with the complainant. The complainant stated that she was sitting at a red light and she was struck by the defendant, and then the defendant left the scene. The complainant was able to get the vehicle's license plate. The complainant followed the defendant through a residential neighborhood where the defendant lost control of the vehicle and crashed into a house about a mile from the original crash. The complainant estimated damage to be around $2,500. It is not copyrighted.
That's what I was going to ask you. Okay. Mr. Castillo, I'm going to find that there's sufficient probable cause to go forward with your case. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you in the jail because they sweep it every single day, every couple hours. If they find you in there, they will place an immigration detainer on you and you will be stuck like Chuck in there until this case is over with. And then you will be shipped off to immigration where you will sit. It takes 9 months just to get a 911 tape here. So you will sit for that time, then shipped off to immigration. I don't know what your status is, but if you're not here with permission, you better live with a halo over your head and not violate any conditions that I put on you now. I'm ordering you not to drive. You do not have a Texas driver license. You do not have liability insurance. You are not to drive. I don't care what is going on in your life. I don't care that you need groceries. I don't care that a baby needs to go to the hospital. If you don't have a Texas driver license and liability insurance and approval from us, you are not allowed to drive. If I find that you break this condition, your bond goes bye-bye. You have the ability to hire a lawyer.
¿Ocupar su propio abogado? No. ¿Usted puede ocupar su propio abogado, sí o no? No. No.
I can have you fill out an application and I will take a look to see whether you qualify for an appointed lawyer. I need to know everything about you. We are filing conditions that you're not to drive. Do not leave until you sign our bond conditions. Deputy Miranda is now going to give you an application for an appointed lawyer. I will have you sign a receipt with Victoria, and then we'll have you take a seat in the jury box, sir.
Was that financial affidavit?
Yeah.
All right, Judge, next is page 8. Brad, come on up.
No more Spanish speakers?
No, they'll tell.
Okay. Hey, what's up, girl? Good to see you.
Please take a seat. Yeah.
Good morning, Mr. Reyes.
Good morning, Your Honor.
Always a pleasure
to see you.
Hi.
Judge. Same here, sir. Looking sharp, Judge.
You're Miss Grab?
Yes, good morning.
Good morning, ma'am. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 9th, 2025, at approximately 1:08 a.m., an officer observed a vehicle on the 5,000 block of Westlow Road, Harris County, Texas, speeding, going 58 miles per hour in a 40-mile-per-hour zone. This was confirmed by Officer Rear. The officer followed the vehicle and observed the vehicle to fail to maintain a single lane several times. A traffic stop was initiated. The vehicle did not initially stop. The officer initiated sirens, at which point the defendant's vehicle increased in speed and continued to fail to maintain a single lane and failed to signal lane changes to get around another vehicle as the officer was in pursuit. The vehicle finally came to a stop. Officer made contact with the defendant, the driver and sole occupant of the vehicle, and observed the defendant to have red bloodshot eyes, thick slurred speech, and the strong odor of an alcoholic beverage upon her breath. The defendant admitted to coming from a wine bar and said she had 2 glasses of wine. SFSTs were conducted. 6 out of 6 clues observed on the HGN, 5 out of 8 clues observed on the walk and turn, 3 out of 4 clues observed on the one-leg stand. The DIC was read, and the defendant consented to a breath test. The results were 0.100 and 0.101.
You said she was going 50 speeding or 40?
58 miles per hour and 40 miles per hour.
Got it. Okay. All right. Ms. Grab, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Sure.
You have a lawyer. He will take care of you. Because you do, I will waive your appearance. Just stay in touch with him and he'll tell you if and when you have to come back to court. For now, we'll have you go to Victoria, sign a reset. Oh, does she have a license?
Yes.
No prior DWIs?
No prior DWIs.
Okay, we'll have you sign a reset, Victoria. You're not allowed to drive unless you have valid liability insurance as well. If you don't have car insurance, do not drive. That is a condition of your bond as well. Do you understand?
Yes, sir.
Okay, I'll have you sign a reset, Victoria. You'll get with Fleischer your bond conditions and you're free to go.
Thank you.
Take care.
Right this way. All right, Judge, next is page 22. Wolf, come on up.
Again, we're continuing to ride with Judge Fleischer rather than court hop because he's definitely the most intriguing court at the moment.
You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 7th, 2025, Officer 1 was dispatched to check by a unit at the 3800th block of Redville Street regarding a minor crash. Officer 1 made contact with Officer 2, who on-viewed a 2 motor vehicle accident. Officer 2 observed the defendant operating a silver Ford minivan and crashed with a black Honda Santa Fe. Both drivers were moved to a gas station. The witness observed the defendant driving the silver minivan and stated she observed the defendant crash into her. The officer observed the defendant to have bloodshot, glossy eyes, and sluggish speech and poor balance. SFSTs were administered, 6 out of 6 clues on the HGN, 5 out of 8 clues on the walk and turn, 3 out of 4 clues on the one-leg stand. The defendant was placed under arrest and read the DIC, and he consented to provide a blood specimen.
It's not back.
No.
Prior to DBI, just one from with us or any more?
It looks like there is a pending DWI from Galveston County from back in 2021.
Can you please confirm whether that is actually pending now? Because I'm going to have big issues if that is actually pending. Please. I'm going to find that there's sufficient probable cause to go forward with your case, Mr. Wolf. I'm ordering you now. Just take a seat for me in the jury box. I'm not ready to go forward. I want to know if you have an open DWI.
All right, Judge, that's it for now. The council needs to approach.
Anyone? Oh, I know I got that. Greg. Are you ready?
Yeah, hey Judge, how are you?
Give me 1 second, Greg.
Yeah.
Espinosa, Jesse Espinosa. He's one that we submitted the PTI, but they're still evaluating it. And they just states that, and I guess we do too, need more, respectfully ask the court for more time to consider.
Has it been, everything's been submitted?
Yes, sir.
Is he on the docket today?
Yes.
Okay.
This is the one that we rolled from yesterday, right?
So.
Did it?
And we had scroll the case for the month.
Los Santos? So we reached out to Judge Geis, and we have still not heard back from her yet. Reached out to her yesterday. Ashley Geis, she's.
Everything's filed, right?
Yes.
Okay, all right, so we'll give you a week.
Thank you, sir. Thank you, Your Honor.
Of course.
Thank you, ma'am.
All right, now is.
Ralph, has he done a TRAS yet? Okay, so let's do this. So if it's not approved by next week, I'll waive the appearance. If it's approved, he needs to be here to take a TRAS. And we'll send him to do a walkthrough, okay? Okay, for sure. Okay, Greg, I'm sorry.
Hey, Judge, I think you took my client into custody. It's Mr. Goff. There may have been a felony warrant. I don't know if y'all did PC on this. This is just a marijuana case.
Yeah, I did PC on it. I found PC already.
Okay.
He's probably gonna hit felony court Monday, so if you want to set it for sometime next week, I'm happy to do it, or if you want to do it later, it's up to you.
Yeah,
Whatever
I
you
mean,
want, I'm happy with.
I'm in your court Tuesday. I mean, well, actually Tuesday, Wednesday, and Friday. So I don't care whatever day y'all want.
Pick a day.
I just don't know when he's going to felony. I would just do the day after. So you want to shoot for Wednesday just in case?
Yeah. Done.
Okay.
Did you get anyone else?
Not yet. I'll jump back on if I get someone.
Judge Delliscall?
Yeah, Wednesday.
Okay.
Judge, on this total, NCIC shows the Abigail sending out to call house.
Please, I'd like to know. This bonded, is there a warrant has been issued, you know? I mean.
But it's just filed by first.
Okay, take your time. There's no rush. We got plenty of time.
I'm gonna. Yes. Yes, whenever you're ready to just approach, we're gonna try to work in the range. I'm using GPS right now.
Mr. D.
Yes, sir. Hi, I'm here on Mr. John C. Joseph. It's my understanding that you want to talk to him and see why he didn't appear in court on his last court date.
Is he here?
Yes, sir. Mr. Joseph.
It's just.
So this is basically an arraignment.
Yes, sir. I understand that we were going to do it as an arraignment.
He's been AWOL. It's now 400 days, 350 days old. Mr. Joseph, you're charged with 2 cases. You're charged with burglary of a motor vehicle. You're charged with unlawful carrying of a weapon. Your cases are now 352 days old. It's time to decide what we're going to do. Do you have offers on these cases?
No, sir. We're still waiting for the security video.
We do have an offer, but yes, we are waiting on the security
I
video.
need you to get on it
Absolutely.
like yesterday.
Yes.
I'm ready to set this case for trial. Way too much drama, and I'm not gonna just.
Yes.
Mr. Joseph, I'm now going to put an ankle monitor so I know where you are at all times. If I find that you have one on now, you take off on me again, I'm gonna make your bonds extremely high. Do you understand? I will
Yes,
give
sir.
you a big flight risk and the bonds will go very high. At some point, someone's gonna stop ponying up all this money. You're just giving free money to bonding companies every time you take off, man. That's all you do. On your burglary case, you're not to have any contact with the complaining witness in these cases. You're not to be in possession of weapons.
Did you say, are you have something going
Yeah.
From, is it from Harris County?
Mm-hmm. I turned myself in the other day and they ain't doing nothing better.
Don't say anything. I don't want you to say something. Perhaps the magistrate put it on.
I don't see any magistrate conditions, but.
He's got 2 cases. Look at the other one, please.
And here of them were supervising an ankle monitoring order. We had one on him back in April of last year, but we haven't been supervising it since June due to the warrant.
All right, I want to go back to the original bond conditions that had a curfew with the monitor on now. No alcohol, no dope. What do you do with yourself these days, Mr. Johnson? Mr. Joseph?
I just started looking for a job. No, sir. I just started looking for one, filling the application.
I'm going to bring you back in 2 weeks. I want to see what you have done to get a job. Did you graduate from high school?
No, sir.
That's what we're going to also work on as well. I want to see what you've done to start working on your GED as well. I'm giving you 2 weeks. If you've not done anything, it's not going to go well for you. Do you understand?
Yes, sir.
Okay. All right, Mr. D, we'll give you a couple weeks, but I want him back in 2 weeks here to see what we've done to either get a job or get his GED.
Yes, sir.
Okay, if nothing, then it's gonna go well.
Yes, sir.
All right? Hey, hold on, Mr. D, I'm gonna have talk to Shatori to give him that paper for GED so he can get free.
I'll make sure you have the meetings to get it.
Mr. J, just want to go ahead and put that in. Well, page the 30. Via Sana.
Vic, I granted all these.
Okay, no, that's fine. He has a driving on the conditions as well. Oh, yeah, I was thinking about. Oh, okay, yeah.
Okay, well, there's a lull in the action in Judge Fleischer's court. Let's go over to Judge Sheila Johnson and see what she's got going on this morning.
My main and last name. I got married since then.
Okay, your last name is Harris? Okay, got it. All right.
Yeah, because he got married, Your Honor, and changed his last name.
Okay, gotcha. All right. Okay, well, for purposes of this, I'll call you Mr. Coleman. Is that okay? Oh, this is going to be a little bit of a challenge.
I'm sorry, Your Honor.
It happens. He's totally frozen. Tell you what, if we can get him back, I'll pass it for 2 seconds. I got one other thing I could do.
Okay, Your Honor. And then when he does, yeah, okay.
Yeah,
You can pass it, and when he comes back, I can make a quick record and hopefully he could be on here.
Yeah, okay. Jessica, could you start Andre Reynolds?
Right.
Okay, this is case number 22M00720SD, People State of Michigan versus Vondrae, VONDRAE Reynolds.
Sean Bishop on behalf of the people.
Good morning, Your Honor. Tropius on behalf of Mr. Reynolds. Mr. Reynolds, station 8.
Mr. Reynolds, good morning. And you are here today for a pre-trial. This is an operating while intoxicated, a second offense. So because it's a second offense, it's still a misdemeanor, but the maximum penalty increases to up to 1 year in the county jail. And then that fine goes up to potentially $1,000, or you could do 5 days to 1 year in jail with some community service and all these other conditions, such as possible vehicle immobilization, extra points against your license, and suspension of the license as well. So you understand the charge?
Yes.
Okay. And you certainly have a right to trial by judge or by jury on this charge with your lawyer representing you. And you understand that? Okay, Mr. Starr, how would you like to proceed? I'm assuming you have some discovery.
Yeah, pleading guilty to felons.
Okay, no offers. Okay. You got your head shaking. What's wrong?
I have another case, that I'm trying to deal with also, with the friend of court.
Okay.
I can't be bounced back and forth because, I think recently got, a chance to really start seeing my kids again, so. Whether or not, I can't fight this case again.
Is that what you're saying?
Yeah, so. Just guilty, I don't have enough evidence, to prove that, somebody else was in the vehicle, so I'm guilty.
Oh, you mean somebody else was driving?
Yes. So, shows that I have no evidence, no proof on my behalf.
Well, what happened to the person?
They vacated. They was already on no police contact, so.
Oh, I see.
Everything's left on me, so I take responsibility for my actions.
Well, he said he really wasn't driving, but the person vacated the car and he doesn't think he can prove it. But why would I take a plea from him if he wasn't?
We can set this for free.
Yeah, I think so. Yeah, let's just see if they can prove it. Since you to do anything, they got to prove you were driving. But if you and your lawyer sit down and talk about it, you might have something that he could do that calls that into question. I don't know. Okay? Because I don't like to take pleas of guilty and give people records if they saying they weren't doing it. You know, who takes a plea from somebody innocent? If you're innocent, why would you plead guilty to it? Just let somebody convict you. But why would you say you did it?
I mean, right now at the apparent moment, I have things going on.
That's okay. So we don't do that. We do not put convictions on people just to make it quick because they got busy. You want to walk around with a criminal record because you're busy?
No, not really.
All right, then. That's what we don't do. No, you stand up for yourself. If you say you didn't do it, you have a trial. I'm not going to accept a guilty plea. So you don't have any choice because you're saying you weren't driving and you're in the car and somebody left or whatever the circumstances were. And so you were there. I don't know what the situation was because one good thing about me as the judge, they don't give us the police report. So we don't know. Only the prosecutor and your lawyer know. And you need to work with your lawyer to see if you have a defense that you want to present. If you don't have a defense you want to present, that's okay, because you don't really have to present a defense. They have to prove you were the one driving.
I understand.
And the rest of it too, that, you know, obviously that you were intoxicated and either.
I was not inside.
Okay. All right. Well, don't say too much.
Let's just get a jury trial date, Mr. Reynolds. No, can't take a plea,
All right.
so let's get a jury trial.
Okay. Jury trial date. April 8th.
Judge Fleischer has returned, so let's go ahead and go back to his court.
But it's,
I trust you.
yeah.
You know, you're the best, but PSI, it's just,
Dog's wrist there, but the state was at 15, so.
yeah.
Melgar. Daniel Melgar. This is my fault, Judge. PTI packet. PTI was yesterday
Okay.
to Abigail and.
Well, not to Judge Geis, right?
Yes.
Okay.
I think
Everything's submitted?
Everything's submitted. All the discovery is turned over. The point was 6, so it's just a little bit about the, I think he will.
Why? So were you denied?
We were told to submit a mitigation packet, yeah.
Okay, so it wasn't a denial and then you appealed,
Correct.
right? They just submitted a mitigation
We
package.
submitted a mitigation
Got
packet.
it. All right, we'll give you a week.
Sounds good, Judge.
Hopefully we can have a decision within a week.
I hope
If no
so.
decision is made, I will waive the appearance. We'll give them a little bit more time.
Okay.
If it's approved, your guys got to be here so we can send it for a T-Rest.
Okay.
Okay?
Sounds good.
Yes.
And then we'll just come back. Hopefully they got it within a week to make the decision or not.
Sir,
Yeah.
it's good.
Okay.
Judge, thank you. Nice to meet you.
Good luck, Vic.
Thank you, sir.
Okay.
Yeah.
And a possession of marijuana.
We'll see which one for.
In a moment as well, so I guess you can look at the looks now. Once I check here, that is right, yes. Okay, I do have your signature. Yeah. Okay. All right.
Can you get your signature? I'm going to chat with all of the papers. You know, I can't listen.
For now, we're going to. For now, yes. Mr. Kaufman?
Hi, Lori. I'm wondering whether you were waiting on someone or,
Mr. Kaufman, Devin Kaufman.
okay.
Go ahead and sign for me.
Happy Friday.
Happy Friday.
With a K or the C? I see, okay.
Morning, Judge. Sir, you can approach it.
I know you?
Hey, forget about it.
Forget about it.
Yes, sir. That's what they gave you. I'm gonna go with it. If you don't have any holes, okay?
Do you guys show any holes on Mr. Kaufman? Are you on probation or parole at this time?
No.
You were on parole in 22. Is that over now?
Yeah.
Okay, so I don't show any holds on you now.
Is no holes?
I don't see any. Do you guys? You
I don't
guys?
see a hold, no.
Yeah, we don't see any holds. But if you continue with what this has happened, and this keeps happening, the sentences just get longer, longer, and longer. All of it self-control, Mr. Kaufman. You're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 15 days in jail with credit for the 7 days that you've done. You need to understand that this is going to go on your record. From now on, you're facing a minimum of 90 days in jail. Do you understand? So, Lori, the trespass is being dismissed.
Are y'all dismissing the trespass?
Believe so, yes, Your Honor.
I mean, the qualitative work are, I mean, full dismiss the trespass.
There is a trespass, right?
Here's a trespass. Was there plea paperwork for the trespass?
I'll say.
So they're going to dismiss the other case that you got. But like I said, you're still facing a minimum of 90 days in the future. So you pick up another case, it's just going to be a long time. You understand? Yeah.
Yes.
Yeah. But if you want something, if you need something, we have services for you. If you need a place to sleep, you need food to eat, we got you. All you got to do is ask. But this, you're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, you give up the right to appeal, Mr. Kaufman. So once you plead guilty, it will go on your record. You can never take it off. Is this what you want to do? How do you plead to the offense, sir? Guilty or not guilty? I'm going to find you guilty. I'll send you to it. Good luck, sir. Thanks a lot. James. Yeah.
Judge, can I start with Alator Aristelsi for bond violation? She tested positive on 3/4 on March 4th for cocaine, Judge.
Can you bring her up, please?
And Judge, this is her first bond violation. If you'd be willing to give.
Ordered you not to use, you're now testing positive for cocaine. That's unacceptable. No, I'm not going to let you go. Marijuana, alcohol. No, you're testing positive cocaine. Unacceptable. I order you not to use. Now I have to take further action to ensure that you're not using. First, I'm going to revoke your bond. You go into custody.
Judge, would you allow her to do a walkthrough bond?
No. I need you to realize that we mean business, that when we tell you not to use, especially cocaine, you're not to use. I'm sorry.
Would you set on that, Judge?
$5,001.
And Judge, I have two more. I have Enrique Flores.
Enrique Flores, come up.
And Judge, on this one, he was in lockout since March 6th. He missed a recalibration appointment. He was working in San Antonio. He does construction work. He didn't know he had that recalibration appointment. He's no longer in lockout. And so I think it was just an issue. He did not know he had that recalibration appointment, Judge.
This is not a burst bond violation with him missing.
I think it might be the second, Judge.
Judge, yes, it's the second. The first one was for the same thing.
Take your time, no rush. Deputy, ain't you going? I need your help. No? Did we let him go the first time?
Yes, Judge.
We didn't take him into custody the first time?
No, Judge.
Unacceptable. He now goes with you. No?
What would you set his bond at, Judge? 5,000?
Then I know. What's the last name again?
Flores, Judge?
Thank you. Yeah, 5,002.
5,000?
Yeah.
All right, Judge, and I have one more, and it's Gomez.
Okay. Jorge Gomez, come up.
So Judge, he did take a drug test today because he had failed to report for a drug test on February 21st, and he tested positive for marijuana.
You see how many people we've taken into custody? I ordered you not to use, and you're now testing positive. If I find that you ever test positive again, I will put you in jail. Do you understand? When I say don't use, I absolutely mean it. You will get tested in 50 days. If I find that you continue to use, into jail you will go. Do you understand?
Yes, Your Honor.
Yeah. Absolutely no tolerance here for it. And the next time you miss an appointment, likewise, you will go to jail.
Yes, Your Honor.
Thank you, Judge. In 50 days, Judge?
Yeah, reset 50 days must appear.
Okay, thank you, Judge.
Thank you, Judge.
Guy number 3 got lucky right there. I thought for sure Judge was going to go for the trifecta on that one. He was kind of on a roll, but, you know, probably not as serious. Yeah, he got lucky. We're continuing to monitor other courts. Quite frankly, it's a little quiet out there, though, all of a sudden. A bunch of judges that we monitor have called it a day. Currently, the only ones really going are Judge Fleischer and Judge Johnson. Of the ones that are worth watching, and Judge Fleischer's more intriguing, so we're going to go ahead and stick with him.
He was on bond at your court with AFM and then picked up a continuous, same complainant. I've talked to the prosecutors. They're going to dismiss this AFM once he's indicted on the continuous. I've let my client know that. So I just want to get a reset till the day after the felony date.
Got it. I'm gonna revoke the bond on our case, though. He's on bond. It's set at 1,000. So he picked up another assault against the same complaining witness, you say?
Yeah, his nephew. It says.
So I'm gonna revoke it. I'll set it at 5,001.
Okay. Thank you, Judge.
And then I guess just keep us in the loop. The felony set for 4/28. You want the day after?
Sir.
Yeah, is that okay? The 4/29?
Yes, sir.
Okay.
Can you not hear? Okay, yeah. Thank you.
Who's that?
Page 38.
Mine's a
Oh, okay. Oh, you are, okay. 429 after the felony?
Yes.
Yeah.
You were both somebody. Who was that?
Flores.
And, oh, no, not those. I thought one Will was talking about. That's the last page. That's Sandy Mango.
Oh, that's the one you just wrote, Judge?
Yeah, on Wenzel.
May I be excused, Judge?
Is that it, Will?
That's all I got, Judge.
Okay, man. Have fun. Good luck with the interview.
All right. Thanks. Have a good one.
A little bit with regular documents, I have some 3 times, so each document is assigned to me. I didn't work them. First one is gonna be
Okay.
Required to me, and all violations, random drug tests. They don't Yes.
Hey, on his first case that we took in, Articelli, when she bonds out, I want to do testing like crazy. So the, like, weekly. Greg, do you need me?
Yes, Judge. I was appointed to a new one. It's a DWI Class B. Angel David Mejorado.
Okay. Mejorado, come up. Okay, that is Mr. Gregg, who has been appointed to represent you. We've given you a lawyer. It is your responsibility to stay in touch with him. He will tell you if and when you have to come back to court. You know the conditions. Don't use. I'm not asking for much. I just want my street safe. Don't use. You see what happens when you use. I have one person after the other. We're gonna have to, you know?
Sir,
We don't need another sardine. You know what I mean?
I understand.
Okay. We'll have you sign a reset. We'll get you with your paperwork, and then after that, you're free to go.
We have this information.
Yeah, the reset will have his phone number on it. You must get in contact with him. In fact,
Call me to check in, okay?
you
Yes, sir.
get his
You get
cell
out of
phone,
court.
so I
I
can
want
give
to
it to
talk to you about it.
I'm gonna
Okay,
get
I
your
will-
cell phone real quick. Greg, give me 1 second.
Sure.
Judge, May 13th through the 15th.
Let's see. Let's go with the 14th.
Okay.
Thank you.
Okay, thanks, Stephanie G. All right, come on, Greg, I'll give you.
All right, Judge, that's all I have. For now, again.
Is that a 6168?
6168.
All right, there it is. Okay, man. We'll have you take a seat. We'll get you with your paperwork, and then you're gonna be free to go. Okay, he'll
and
call you
I
here
got the
within an hour.
number. Thank you, Judge.
All right. Come on up, please.
Yes, I can.
All right, so Mr. McGee, you've worked out an well, not you, your lawyer has worked out an incredible deal. You're charged with five, it's 5 open cases, right? Shh. You're charged with evading arrest, failure to identify oneself, evading arrest, theft, burglary of a motor vehicle, and I think that's it, right? As part of the agreement, you're going to plead guilty to the burglary of a motor vehicle and the evading arrest. You need to understand that both of these cases are enhanceable cases, meaning if you pick up another one of these cases, it's very possible they charge you with a felony offense. Now, on the burglary case, it may be 2 or 3. I think it's a third, it's a felony. But on the evading case, you pick up a second one, you're looking at a felony charge, years instead of days. You understand? So I don't know who you're hanging out with. I don't know what you got going on in your life, but you got to surround yourself with better people, because you start the wrong people, they're going to bring you down. Don't become another statistic. We have enough Black and brown people in custody now. Don't become a statistic. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you plead guilty to these cases. You can't do anything else. It goes on your record. It'll be there forever.
Understood.
How do you plead to both cases guilty? Mr. McGee, if you need anything, just come back, talk to me. I'll get you whatever you need. If you want a place to stay, food, cell phone, tablet, we can work just about anything to get you what you need. It's never a problem.
Yes, sir.
But would you get out there, you get on the street, you gotta be careful, man. You get for one life. You don't get another one. There's no redos. Good luck, man.
Understood.
Yes. It's 30 days, I'm sorry, 30 days in jail, credit for the 29 and 31.
Okay.
So we need 3 dismissals on that, right? You did? Okay.
Yeah.
So while there's a lull in the action here, every judge of significance that we monitor beyond Judge Fleischer has actually called it a day already. It is Friday, so people like to get their weekend started early. I do have eyes on a few other judges that we don't normally follow, so if anything interesting goes on there, we'll cut to it. Otherwise, we'll just continue to run with Judge Fleischer the rest of the way.
The time served often on that same day.
I mean, if she wants to, she's old enough to know. It's not like she's a child.
She has a little bit of a criminal history, so she.
Oh,
She could.
does she have a prior DWI?
No.
Okay, as long as she doesn't have a prior DWI, then I'm good with whatever you guys want.
She could probably qualify for the DUI PTI if she provided mitigation, but because of her priors, I don't think they'll auto approve her.
If they approve?
Not automatically.
There's a chance you'd be approved, but it would require mitigation.
Right.
Yeah. So all that to say, it might just take a
Yeah,
little
just talk to her. I'll do whatever you guys want to do.
Okay, let me talk to her right now, Judge.
Yeah.
Thank you, Judge.
Wait, she's right there. There's no room. I mean, that's not fun.
Right, they're gonna send this. I just want to make sure if I got this link.
Well, hold on, because she might be doing something different. She might be taking something.
Okay, perfect.
Ma'am, do you have a case in here?
I have lots of cases.
No, I know you.
Oh,
Behind you.
sorry.
No. Yes, what is your last name?
Yes, Marcos, Rodriguez attorney. Marcos and
What is your last name?
It's an arraignment, Judge, on page 2.
It's weird he's not here.
Yeah, I think he had, it's spring break, so he had, I forget her name, helping him out.
Hmm. Do you want to go ahead and do it?
Okay, we have I'm always for it.
Is he out of town? Do you know?
I assume as much, because she's been all week covering for him.
Who? Oh, right.
Yeah, I forget her name.
Yeah, I mean,
But for Mr. Flores, we're good on that one? We're good on the.
yes, absolutely.
Okay.
Yeah.
So let me, oh, for the jury. Okay, yeah, you can take it, just wait under it for me. I got it.
So the new date we're talking May 15th?
For arrangements only, it's 2 months out.
Yeah, so ready? Hey, good morning.
Get appointed to Mr. His name,
To who?
Ramos,
Okay.
Carlos Ramos.
Is he in jail?
Yes.
This is a little bit, long-winded one, so I can.
You look like you were kind of iffy.
I'm playing catch up, Your Honor.
Well, so just
Too.
to give you some background,
There's no rush. Take your time.
so in August of 24, he picked up a third-degree PCS.
I remember now.
He had attempted auto theft. That was a cheap case. He did it for 18 months. That was done in September of 20. Then in March of this year, he picked up 1, 2, 3, 4 third-degree theft cases.
We were talking about this yesterday. It looks like it was one of those burglary rings where they're taking like tons of cars and is it like a chop shop
It
type
sounds
thing?
like that sort of. I don't have all the details of the felony, but that's what it sounds like to me.
Okay.
You know. What kind of puts us down here in a little bit of a bind is all of the allegations of the MHA are all the felony offenses.
He has no technicals? Really? He was doing good on probation?
doing good on probation. He's
Wow,
completed the
until these
entire-
cases, obviously.
I can maybe get him on the co-defendants. One of the conditions was having no contact with co-defendants, but I don't know who they are.
Can you let her know? That is, I mean, that if that's a condition, that's a condition, right? One of them is, I don't know, would you mind sharing who the co-defendants are, just to see if that's something? And then, I can give you time regardless. He's at no bond on all those cases anyway, so if you want to set it maybe a week or so out, that'll give you time as well. And then you can always just amend it at any time, if it is. If it's not, and this is the only cases, obviously we can't really.
Move forward.
The problem is that that's gonna take
Right.
forever.
Yeah, and I can see defense's position of, they can't take anything because it's basically
Yeah.
accepting responsibility.
Unless there's some kind of technical. So I guess share that and we'll go from there. Take your, I mean, if you want to set it a week to.
Sounds good. I'll set it for a week.
Okay.
Thank you.
Thank you.
You ready?
Yes, sir. Good morning. Crystal Rollins.
So who do you have?
Crystal Rollins.
Okay.
For a bond violation this morning.
Come up, Mr. Rollins. We have a problem. You were ordered not to use any illegal substances. You have tested positive or something. I don't know what it is, but I need you guys to talk to see. All I know, it's an amphetamine. I don't know what it is.
It's her prescription medication, Your Honor. I actually have, I don't know if you want.
Hold on, just. Can you show it to them so that they can see to verify that that's something that would, with Felicia, yeah.
Yes, sir.
And then just take a seat from the jury box.
Yes, sir.
Like, I don't want to ding if it's actual like medication that's prescribed that she's taking that could give that kind of positive result. So let's take a look to see And then I'm hoping that that's what it is. Vic, she was here. Yeah.
Judge, Flores was also brought into custody. Would you do time served on him? They just offered it to him. He was the one who was in lockout, Judge.
Right, all right.
Wanted to ask you before we bothered with the plea paperwork.
Just we're willing to offer time served today.
Okay.
Thank you, Judge. Did you write that up?
Yeah.
Thank you, appreciate it.
No problem.
And Judge, would you waive the DPS fine for him? I am court appointed judge.
Okay.
Thank you,
I
Judge.
need to suspend his license.
How long would you like the suspension to be?
180 days.
180 days, okay. Thank you, Judge. Let me tell him.
Judge, I'm having her email the.
Okay. Yeah, for sure. Well, no, I know it's a valid prescription, but would it test positive for this?
Yes.
You know, that's my
Yes,
concern.
it would.
It would?
Yes.
Okay. Do you know that for sure, or are you waiting for them to verify? Okay. Okay. Coming up, Miss Rollins. Okay, you ready? Did you guys let pretrial know that she's taking this medication? Did she?
We were not notified of it. If we were,
Right,
we
okay.
did.
So-
Not something we would have submitted a bond.
Come on up. In the future, when you're taking something, you have to let them know what you're taking so that they don't ding you on a bond violation. Because a lot of times we get people here taking medications and it'll set something off. We don't know. So we're assuming that you're taking something you're not supposed to. So I'm not going to ding you on it. You're fine. Just if you're taking anything else, please let them know so that they won't file these reports and we have to drag you over here for nothing, you know? Okay? Yes, ma'am. Okay, thanks. We'll just give you a normal reset. Okay. Good luck, Ms. Rollins.
Just because I it's right next door.
The only door will be for the one. Lines up. Those guys. Yeah, I didn't know. I ended up having to take them off too. No, I did.
Oh, she's still there. I'm
I think Miranda was again.
Once again. What do you, I think?
Fleischer.
You want some? Yeah. As much as you want. Help yourself. Shush.
Second, Judge.
You ready? Hey, good morning. You want to do the arraignment first or which one? Okay. Come up, man, please. So she has a co-defendant. Do you guys represent the co-defendant? Do you know?
No.
No?
I believe the defendant also has a felony because he had prior thefts on it,
Really?
but she is a first-time offender. And her, yeah. And her involvement in it is not as much as the co-defendant's.
Ms. Ayala, you're charged with, you speak English, ma'am?
Yes, sir.
Okay, Ms. Ayala, you're charged with theft. Shh. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On March 9th, 2025, at approximately 5:43 p.m., an officer was dispatched to a Best Buy in Houston, Harris County, Texas, in regards to a theft. The call notes advised that the suspects had left the location in a red Dodge Challenger with a temporary tag that started with 74. The officer located a vehicle consistent with the description about 0.8 miles from the business. The officer was also given a description of the suspects. A traffic stop was initiated. The officer immediately recognized Defendant Sauceda from previous thefts from Best Buy. Defendant Sauceda stated he took 2 items from the Best Buy without paying. The passenger, who is identified by her Texas driver's license as Defendant Ayala, and Defendant Sauceda entered the store and went to the cell phone station. Defendant Ayala distracted the cell phone employee while Defendant Sauceda used a pair of scissors to remove 2 cell phones and exit the store. Shortly after, Defendant Ayala received a text message from Defendant Sauceda, and she immediately left the store without purchasing any items. The total value was $1,499.99, and the 2 items were located inside the vehicle.
Don't talk about the
Ms. Ayala, I'm going to find that there's sufficient probable cause to go forward with the case. I'm now ordering you not to have any contact with the co-defendant in this case. If I find that you do, I will revoke your bond, put you in jail. No more PR bonds. I'm also ordering you and barring you from going to any Best Buy in anywhere. Do you understand? If I find that you pick up a new case, if I find that you violate these conditions, that's it.
Yes, sir.
So do you mind filing those conditions, no contact with the co-defendant, no going to any Best Buy, anywhere? And then now you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you, I will issue a warrant for your arrest. For now, I'll have you sign a reset with Victoria. We'll have you take your seat in the jury box. So we'll get your bond condition. We'll have you sign it. And after that, you'll be free to go. Okay, thanks.
Judge, I have 2 bond violations. The first one is Torres Noe. His bond violation is for failing to show up to a random UA. I tried reaching out to him, Judge. Apparently, he got deported. So that kind of explains why he's.
Sure about that? How do you know?
That's what the family told my office.
Got it. Okay, I'm gonna end up revoking it then, because I
Yes.
can't just leave it open. I'll leave it at 2501.
Yes, Judge.
Okay.
And then you reinstate if he's got.
I mean, let's see, but more than likely, like if it's not his fault, they just up and took him, then, you know,
Yeah, his family says he was detained by ICE and deported.
just I would reach out to the family, let them know, hey, if you're gonna get him back, do it the right way. You know, like get permission first, and then if I see that they do that, then of course, absolutely, I would reinstate it, so.
Sure.
Who's second?
And then Judge, the second one is gonna be Lambert, John.
With an L.
Yes, Judge.
Come up, Mr. Lemberg.
And Judge, I spoke with Mr. Lambert. He had a BAC of 0.03 on his interlock. I spoke with him about the incident. We talked about, let's just be honest about this and let you address it. We are asking for an admonishment because it is his first bond violation. He said he went out with friends on Friday had some to drink. He didn't drive that night, but the following day, he didn't know that he was gonna be positive when he tried starting the car, and of course, the ignition interlock picked on it. I did admonish him that, your bond conditions are no drugs, no alcohol whatsoever. It's not only when you're driving, but throughout the pendency of the case. He understands that now. He is just asking if you would give him an opportunity change.
You had a WI 2 years ago. Now you've got another one. We tell you not to consume alcohol, yet it's happening anyways. So either you don't care about court orders or you have a problem.
Yes, Judge.
Have you seen how many people we put into custody?
Yes.
I'm now going to put a monitor on your ankle so I know that you're not consuming at all. I'm going to put a scram monitor that detects alcohol through your perspiration 24 hours a day, 7 days a week. I don't give a rat's behind what your next excuse is. If I find that you ever test positive for anything else again, I will lock you up. No more PR bonds. Do you understand?
Yes, Your Honor.
Your other ankle, I'm now going to put a GPS monitor and I'm going to give you a curfew of 9 p.m. to 6 a.m. If I find that you're out because I don't want you out in the middle of the night, likewise, you will go into custody. Do you understand?
Yes, Your Honor.
It is absolute no tolerance here for it. I don't care what your excuse is from now on. No means no. Do you understand?
Sir.
Okay.
Thank you, Judge. May we be excused?
Yes, ma'am.
Thank you.
By our count in Judge Fleischer's court, I'm up to, I believe, 7 bond violations that he's dealt with now today. That's a lot in one session. And this last guy here, he kind of turned him into a cyborg with the amount of monitors that he put on him. I don't understand bond violations personally, especially when it's when it has to do with the use of substances like alcohol and stuff. I don't know. You get to the point where you're in that position, you got to figure out a way to stop, man. And I get it. We talked yesterday on the live stream about how in my family there are people that have struggled with alcohol, so I understand it. But in the same respect, at some point, you got to step up. I don't know. Anyways, let's get back to the judge, see if he's got anything else going on for the rest of the morning here.
Judge, for reverse, do you want to keep the ignition interlock or just? Yes, Judge. Yes. And so the he said he just has to go on. Okay, so don't let him go until he talks to you. Okay, I just want to make sure I have time. Mr. Robinson?
Just for.
Okay, I'll.
Give you guys a cause number.
Was that no driving?
I'd rather show it, it's the best.
2, you ready? 2555. Check it out, Abby. 445. So 2555445. Read the 2B, please.
Okay. So,
No, don't read it out loud. Not out loud. Read it to yourself.
okay.
I have a problem with this. Not from a no PC standpoint, from the video standpoint. Take a look.
Okay, sir, you can go ahead and sign for me now. Thank you.
Yeah, I'm signing it.
Make sure you.
Hey, can we get Randall? Oh, he went upstairs.
I got posted on 9 years ago, 2016. So he said, I was just waiting for somebody to I read to see what the stadium was.
Just make is the issue that you don't.
Yeah, I mean, isn't there a problem? I mean, what? What's that?
Yeah, I mean, I think we would first have to identify the person and then.
I'm just saying, just, I'm putting it on your radar.
Yeah,
I find that
got
just
it. Yeah.
deeply disturbing. I mean, just, and I don't know. I don't know what can, if, I just. I can imagine that the person would be happy.
Yeah.
I'm signing the 2B now for what it's worth, and then, you know.
I said it's not.
How are you?
I don't have anything in your court today. I'm actually here.
Oh, that's nice. Good job.
Thank you for all the videos.
Nice. Hi, nice to meet you, sir. Well, good job doing pro bono. You know, it's good karma.
I do veterans, come back to PTSD and they get arrested.
That's nice. And I know that we also do a lot to help our veterans out too, you know, because it can have an impact on you. You know, it really can. The PTSD.
Well, I did 5 years of college and I still feel like PTSD, so I know. Anyway.
Well, nice to meet you.
I was upstairs and I was like, I saw pictures and stuff.
Yeah.
Go watch and see if I see anything.
Thanks. It's nice to meet you.
Judge, did you want to go over a few? All right, age 3, Gorilla. 2 months posted that arraignment, counsel died and has said no contact.
Do you know if they want to stay on it or no? They want to withdraw?
No, they usually want to say, Nathan.
Okay, everybody, when we get to the point of the docket where Judge is just signing off on people that haven't showed up and whatnot, he's pretty much winding down for the day. So we're going to go ahead and call it a day here. Appreciate y'all joining us. It is Friday. Have yourselves a great weekend. We'll be back Monday, 10 a.m. Eastern, 7 a.m. Pacific. Again, enjoy your weekend. Thanks for joining us, and God bless.